Namaste. Ladies and gentlemen, we are endeavoring to do a constitution and try and get you the right perspective of our Samvidhan. How Indian is it? Nearly 7 decades that it's come to force. Are the laws archaic? Is the way it's structured, the amendments, the entire ethos of it? How Bharatiya is it? And has it been able to? Does our Samvidhan still carry the remnants of coloniality? Or is it truly Indian? And joining us on this are people who are not only studying this, who are practicing this, who are supposed to know this in and out, but they are also doing a deep dive to understand where the origins of our constitution is. So author, lawyer, and someone who claims India, that is Bharat, J.Sai Deepak is with us, and also with us, joining us. He should have been with us in studio, but he had an urgent hearing, and that's a case that he's been fighting with, along with his senior, his father, Harishankar Jain ji. So Vishnu Jain, namaste. Thank you very, very much. Let me ask you. So I know that you are fighting a fight which you very thoroughly, strongly believe in, and you want to fight a legal battle. But we will focus on the Samvidhan today. Ladies and gentlemen, at the outset, this is something which is a very special gift to me, and I thought I should show it to you. This is the original Samvidhan. It's a reprint of the original Constitution of India, where we had Mr. Raza, the calligrapher, who has written, painted the entire Samvidhan. It was called India in sovereign democratic republic. Often used word is absent. Sovereign democratic republic. That's what they said. That's what they dreamed of our country as. And there's something special. Sai Deepak, there is also Ram, Lakshman and Sita right at the top of fundamental rights. Right. So the Samvidhan has Ram, Lakshman and Sita. It has Buddha. It has the symbol of the Indus civilization. As it says, India, that is Bharat. It's there on the first or the second page, and I'll try and show that also. It has all the signs. And look how beautifully civilization remnants of are. And Article 1, this is the title of Book 2, The Union and its Territory, Part 1. Article 1, first line, it says, India, that is Bharat. But let's ask J.Sai Deepak and Vishnu Shankar Jain as we take this forward, how Bharatiya is our constitution?
So based on my limited reading so far, I am of the view that the constitution happens to be perhaps the product of dual consciousness. Not only would I use the naming of the country under Article 1 as a reference point, but the debate around particular naming, the fact that the overall framework that seems to have been adopted is, let's say, it is significantly inspired by provisions of the Irish Constitution. The 15th Amendment of the United States Constitution effectively finds repetition as Article 14 here. You have several aspects of Anglo-Saxon principles which are applied here. Then the French principles of liberty, equality and fraternity which are captured as part of the preamble. So this is significantly entrenched in the Western framework. But this is also one of those constitutions where there is a provision that specifically speaks of ban on cow slaughter and cow protection, speaks of cow protection. Then there is, of course, Article 295A. Most people know of Section 295A from the IPC, but they don't know of Article 295A, where the Indian state has taken the responsibility from the former Maharaja of Travancore, the obligation of paying rents to the Padmaswami temple in return from the temple. So, continuing obligation. These are obligations from so the backdrop of the politico-legal infrastructure that we have inherited from the Anglo-Saxon model, coupled with our own historical and realities, and it certainly reflects a certain dual consciousness. Whether it suffers from dual consciousness and whether the balance tilts in favor of colonial consciousness, I'm yet to answer that particular question. But at the very least, there is an Indian component and there is a Bharatiya component, both of them being different from each other.
Both of them being different, but it's no. It's supposed to be India that is Bharat. You would have wanted our founding fathers to learn from other democracies, other constitutions, and perhaps bring in what is good. But there have been complaints, Vishnu Shankar Jain, that the laws are archaic. They're more than 2 centuries old. Over the last 7 decades, the Constitution has gone through several amendments. But have these amendments made it more Bharatiya in nature, or has it made it more Western in nature?
See, Anand, very good evening to all of you, and a very good evening to Sai Deepak. And I must say that the Constitution, after amendment, has added more insult to injury rather than fulfilling the dreams which our founding fathers had. Kindly analyze the dichotomy in our Indian Constitution. When the word secular was debated in the Constitution Assembly, 3 times that word was taken down, and by way of 42nd Amendment in 1976, this word was added. And the specific plea was, and the debate was in the Constitution Assembly, that the words secular and minority cannot stay together. I must quote here, and I am bound to quote here, the discussion which Sardar Vallabhbhai Patel had while inserting minority rights, and this is what he said at page 351, volume 8 of the Constitution Assembly debates. This debate is available. He said, I remember, and I'm quoting, I remember that the gentleman who moved the motion here last time in August 1947, when asking for separate electorates, I believe said that Muslims today were very strong, well-knit and well-recognized minority. Very good. A minority that could force the partition of the country is not a minority at all. Why do you think that you are minority? If you are so strong, well-knit and well-organized minority, why do you want to claim safeguards? Why do you want to claim privileges? It was all right when there was a third party, but that's all over. So my point is, unquote. So my point is that kindly see, the founding fathers had an intention that there should be no minority rights in our constitution. And Article 299, which was under the draft constitution, was struck down. But despite the said fact, we have Article 30 subclause 1 or 30 subclause 1 in our Indian constitution, where we give specific minority rights and minority educational institutions are set up. And there are discriminations and dichotomy from that very beginning in the Indian constitution, and the amendment to the Indian constitution by adding the word secular and socialist have added more insult to injury. I have challenged the word secular and socialist which have been brought by amendment, because kindly see, Anand, if someone will read the preamble, it's an oath which was taken on 26 November 1949. It says at the end, we on this 26th day of November 1949 do hereby adopt, enact and give to ourselves this Indian constitution. And by way of an amendment, you are trying to change the oath which was taken on 26th of November and trying to add social and secular. So the point is, what kind of secular we are? When there is such a committee is being operational in India, when there is 5,200 crore rupees which are being spent on minorities in violation of all the principles of Article 27. When we have Article 14, but despite the said fact, there is no issue of gender justice, there is no issue of uniform civil code which is being debated upon. So are we really implementing the constitutional ethos and goals, or are we really implementing the discussion which our founding fathers had in the Constitutional Assembly is the question.
Yeah, it is the big question. You talked about dichotomies. We are a country which allowed ek desh, ek vidhan, do samvidhan for the longest period of time. We are the country which in its constitution has not defined the word minority. It mentions the word minority, it does not define who's a minority.
Correct.
We are a nation in which the overall seeming majority is a minority in 9 states.
Correct.
So then the constitution should be protecting them as minority in these states. Right. So there are a lot of questions that arise. Do you believe that there needs to be a thorough revisit?
So I do believe there is a thorough revisit needed. Let me just add to what Mr. Jain has pointed out. I think the subtext of what he's saying, which I completely endorse, is that the majority-minority debate that goes on in the country today, and that too in the specific context of a particular group which masquerades as a minority and shouldn't be treated as minority under any circumstances, is a restatement of the two-nation theory for all practical purposes, which has been my thesis, especially over the last 2 years. Two, however, having said that, what is critical to note is that when the Constitution uses the word minority, it also speaks of not just a religious minority, it speaks of a cultural or a linguistic minority. So there is sufficient room in these provisions for protection of several sub-regional identities so that they don't get submerged at the altar of a so-called national identity. What was incorporated for the purposes of protection of all these local identities has now become a weaponized tool to push the agenda of one particular community entirely. To the extent that the Minority Welfare Ministry, which was constituted in 2006, is constantly seen as the stronghold or the bastion of one particular community, from its appointments to whatnot. And if any departure is observed in that particular appointment, it is seen as being anti-secular. So I do believe that there is a dichotomy there. But the second important thing is, and to add to what Vishnu has just pointed out, when the word secular was being debated, they were very clear of the scope for mischief using the word secular. And they said that the presence of this word is going to create a lot of trouble, not just to the character of the Indian state, but also with respect to a community that has just witnessed massive bloodshed in the backdrop of the partition, namely the Hindu community, where a partition is foisted upon it. And therefore, knowing fully well that the word secular has several historical connotations, they dropped it. But before the 42nd Amendment, which came out in 1976, there's another aspect that I think that needs to be pointed out, which is on the 24th of April 1973, in the Keshavananda Bharati case, the Supreme Court comes out with a particular finding that secularism is one essential aspect of the basic feature of the Constitution. Now, while I can understand that political compulsions of a particular leader resulted in secular and socialist being inserted forcibly into the preamble, under what compulsion did the judiciary deem it fit to insert secularism as an essential feature of the basic structure of the Constitution when the founding fathers and mothers, because we had both, let's say, genders represented there, why is it that the judiciary chooses to put itself in the shoes of the founding framers of the Constitution and then insert these words? So apart from the fact that elected representatives have misused the Constitution, it is my belief that the Constitution's original intent has also been significantly deviated from as a consequence of judicial interpretation. And therefore, the responsibility for this lies as much on the judiciary as it does on the legislature.
Judiciary as much. And the other thing, Vishnu Jain, is that we always say, ye karna hai to Constitution amend karna padega. The conversation is never, if we want to undo something, let's amend the Constitution. So it's always somewhere, are we progressing towards the idea of India, or are we progressing towards the idea that is not India as envisaged by those who set up this country? Let's say our founding fathers and mothers, as Jai Sai Deepak put up.
No, absolutely. See, I agree with Sai Deepak, and there are a lot of scopes for implementation. I think when we talk about the Constitution and when we talk about the minority rights as well as the insertion of words secular and socialist, that is one area where we have problem. But the second area is the implementation part. As Jai Sai Deepak rightly pointed out, the Minority Rights Article 29 and 30 uses the word religious and cultural minority, linguistic and religious minority. There are two types of minorities under the Constitution, linguistic as well as religious, but no one looks about Sanskrit as a linguistic minority. If we look about the minority rights, Sanskrit as a language is minority in the entire country. But I have not seen a single scheme from past 70 years by any government where Sanskrit is being taken as a linguistic minority in any state, or it has been promoted, or any aid is being given to any institution. We are not being taught our Ved and Shastra. There is no policy so far as any minority Sanskrit institution is being established in any state. So there is one part of constitution being there in its original form, and the other part is implementation. The implementation has been so bad in past 70 years, and the implementation has been on the aspect of only narratives, and the narrative is that we have to treat minorities on equal footing and we all are secular. Let me tell you, I want to give an example, and please try to appreciate this point. The people are never secular. Even if you are assuming, I am saying that Justice Rohinton Nariman, who was a judge of the Supreme Court, he said that forget about secular and socialist being added in the constitution. Even if those words were not added, then also there is Article 14 and 15, and the principles of secularism are enshrined and imbibed in our constitution. I agree with J. Sai Deepak that legislature is also responsible, the judiciary is also responsible. But I am saying, assuming that the principles of secular ethos are there in our constitution from the very beginning, assuming, but kindly understand the dichotomy that whether the people are secular.
Yeah.
You have forced us to be secular. I want to believe, and I want to assume, and I want to have a religious belief that my God is supreme. And I want to give that liberty to a Muslim friend also who wants to believe that the Allah is supreme. I want to give that liberty to a Christian friend also, that he may believe that his book is supreme. But you have forced into my mind that no, I am secular. I have to believe that all religions are at the same footing. I want to ask a question today on this debate. Can a Muslim ever say, or a Christian ever say, that all religions are same? It is only forced upon us to say that no, you are all same. While the fact of the matter is that you cannot force people to be secular. The government has to be secular. If you are believing in secular ethos also.
Correct.
So there is dichotomy from the very beginning. And by introducing these words, so much of confusion has been created that because of this confusion, all these schemes, all these appeasement policies have been introduced. And the Waqf Act 1995 is the glaring example of all that, and including the Places of Worship Act.
So are you both trying to say that our constitution is actually a slave to narratives, and the narrative finds its roots in the two nation theory?
I would say so significantly. See, at the end of the day, we have a tendency, the thing is, whenever a particular film appears in black and white, we end up assuming that people were also equally black and white, which is not the case. The 1940s and the 1920s were as colorful and as grey as it can ever get. Okay, so I don't for a moment believe that there was no politicking behind the drafting of the constitution. But I would certainly say, I mean, I'm sure all of us would agree, that the quality of people in public affairs has certainly come down significantly from the 1940s, which is a worldwide phenomenon. But be that as it may, this is to be seen as a politico-socio-legal document. And therefore, it is a confluence of multiple compromises, multiple decisions, and multiple pulls and tugs. Which is why my constant refrain has been, let us stop treating this particular document as some kind of a religious document. Look at it as objectively as possible. And the problem with, let's say, one of the doctrines of the Supreme Court, which is the basic structure doctrine, is that it binds the future to a particular decision of the past. If, according to you, the decision of the past is so crucial, then you must also respect the original intent in all aspects. But somehow, as Vishnu points out, the original intent is conveniently left open for certain aspects, and in certain aspects, we are tied down to it. There's a serious problem there. So, consider this particular issue. The question of minorities is never to be discussed at the level of the national scale. It is to be discussed only state by state, which means there cannot be a national commission for minorities in the first place, because the question of population and the question of composition is decided at the unit level of the state or the union territory. So if that is the case, who is a scheduled tribe, who is a minority for a particular, let's say, state, will be decided by each state government based on their representation in politics and so on and so forth. Now, going by that logic, a Tulu-speaking person in Karnataka could constitute a linguistic minority. Or Bengalis or Maharashtrians in Telangana would constitute a linguistic minority. That's how the discussion has to be. Now, the reason why Hindus in 7 to 9 states don't get to be treated as minorities, as far as those states are concerned, is that somehow we are fixated on the point that it's only a national count that matters, right? This is the product of 2006. Until 2006, there was no National Commission for Minorities at all. And therefore, for the very first time, under international pressure, under a specific convention, India chooses to constitute a National Commission for Minorities until then, which is a state subject or a state discussion. So clearly, this document is not just subject to tugs and pulls from within. It is equally subject to tugs and pulls from outside. So the human rights discussions that happen across the globe are sometimes slavishly imported here without asking whether first world problems can be foisted on a third world country, which is still a third world country for all practical purposes. We are growing, we'll certainly reach the first world at some stage. My point is, when there are serious problems in terms of, let's say, basic issues, as Maslow calls them, his basic needs, you don't bring in, let's say, human rights considerations from the outside. Because while you'll constantly create rights, does the state have the wherewithal to enforce those rights?
Yeah.
The question is, the judiciary has the luxury of creating rights and recognizing rights. Does the state have the wherewithal to actually enforce them? Is the society ready for these rights? Because every society has a pace at which it moves. And most importantly, we have our own cultural ethos and agencies. African nations today seem to be much more confident standing up to the West in terms of imposition of Western values, but Bharat, which sees itself as the lodestone of all culture, doesn't seem to have the very same confidence when it comes to this imposition. That's exactly why I believe that today, when it comes to issues of feminism, issues of gender, issues of human rights, I am 100% clear that people must be treated with respect. However, constitutional thought and policy thought with respect to each of these issues must be informed significantly by our own cultural ethos and our own native jurisprudence. But as I'm sure Vishnu will agree with me on this point, all these discussions are useless until legal education in this country focuses on native thought systems, which is not the case today. Native thought systems don't find any place in legal education whatsoever. We are constantly taught the jurisprudence of the West. So if that is what is at the education level, what do you expect at the level of policy and ideation?
No, but did this also stem from the fact that within the Constituent Assembly discussions, Vishnu Jain, there were two groups. One that said that we are going to be very, very native in our thought process. We're going to go back and we're going to draft ourselves and align ourselves based on our scriptures, our jnana, compared to the other which said, no, it's the West. We have to look at the West. They are industrialized, they are developed, they are civilized, and we need to throw. And did that prevail? And is that thought now percolating?
I think Anand, you are absolutely right. And the way the indicts, and as Sai Deepak has rightly said, and he has done a lot of research on this point, and his book is an inspiration for all of us. The indict thought process, I think, is somewhat missing in this Indian constitution. And let me give you certain examples by which you will see that how this entire thing has been mesmerized, and under the garb of secularism and under the garb of socialism, how the indict thought process has been murdered, brutally murdered. Let me give you an example which I got through my professional experience. I will not name the institution, but just 1 month back I got a case where one of the minority institutions had challenged that we should be declared as a religious minority before the High Court. The High Court turned down that request. They came to the Supreme Court. In the Supreme Court, the facts of the case were that they have been a minority institution and they want a minority status. The National Commission of Minority had declared them as minority institution. The state of UP said that no, we do not want to declare you as minority. Now the point is, and see the business which is going on in this country, that institution says that we are a minority institution, kindly give us 50% seats. The permission was given, and ultimately, Anand, you know what happened? The minority institution, they filled only 10% seats from minority community. Rest 40% seats were sold out in the open. So that money is used for various other purposes. And kindly see Article 28 of our Indian Constitution, where you prohibit the government institutions to impart any religious education. So at one point of time, you have Article 28. where in any government institution there can be no religious instructions, and on the same time you have Article 30 subclause 1 where you have minority institutions and they can impart religious education, and the government will aid them and fund them.
Correct.
And when that aiding and funding is given, they take that aid and fund also, and they take aid and fund from the general public also, and there is no concept of minority.
Yeah,
so that is point number one. We have seen that within the framework of our constitution, in complete violation of Article 27, Hajj subsidy has been given.
Yeah.
We have seen in the Indian constitution that in complete violation of Article 77, a Prime Minister of the country has appointed Sachar Committee. And recently we came to know that Sachar Committee has been implemented.
Yeah.
We have come to know that 5,200 crores is given to minorities. So these are so many glaring and blatant examples by which we can understand that there is a complete murder of our Indian constitution. It has been not been implemented, and the Indian ethos and Indian values have been devastated by this the implementation.
Totally eroded even the spirit of spirit.
There is no talk on uniform civil code.
Yeah. That is part of the directive principles, to go ahead and outline a common civil code for the citizens of the country that will be governed by the constitution. Yes, Vishnu Jain, quickly, and then I'll bring in Sai Deepak. Yeah.
One more thing I want to point out, that we all know that there is uniform civil code, but it's a basic principle of criminal law that it has to be uniform for all. Now we know under section 494 IPC, a Hindu, if he marries more than one person, he is punished. But at the same time, marry one person, there is no uniformity in criminal law, and especially.
No, I think I've just lost your audio there, but there is no uniformity is what you said. But Sai Deepak, that's the travesty, isn't it? We talk about the right to equality, but hotels are governed by government, none of the other institutions are. You talk about the right to equality, minority rights are governed in section of society, but other other language minorities and in states where certain other communities minorities, they can't have their own institutions.
Correct.
They have the minority rights. And the right to equality itself stands compromised.
Take this example, the Right to Education Act, which has its noble intentions. When it is the purpose of the state and the stated goal of the state to ensure that everybody in that particular age bracket has access to education, why should it make a difference whether you are a minority educational institution or not? And still there is a specific exception that's carved out to say that the Right to Education Act, which furthers a certain universal goal, is exempt from application as far as minority education is concerned. And the two aspects to it. To the audience, I think there are two questions that we answered. If the Constitution and Bharati is the first question. Assuming for a moment that it is as far as the origin is concerned, and that Gomukh, where Ganga comes, is also pure, clean. By the time it reaches Delhi, does it remain as pure as it is, or has it significantly become polluted as a consequence of multiple interpretations both by the legislature as well as the judiciary? In my humble view, whether Gangotri itself is pure in the context of the framing of the constitution is a serious question that needs to be asked. But that problem has been compounded further by the politicking that goes on in the name of secularism in this country.
Very well put together. Ladies and gentlemen, this is such an engaging conversation that we want to continue this, but paucity of time. So Vishnu Jain and Jai Sai Deepak, plenty of food for thought, and thank you for making the time for what is an engaging and eye-opening conversation, although we've just skimmed the tip. So far, we've just skimmed the tip, but then perhaps we will be able to pickle the interests of our viewers to take this debate forward in the days to come. I thank you very much for your time. Thank you so much. Namaste.